decided through the system of PCA. I'll introduce you only a few which are very famous and important cases. Number one, arbitration under the Timor Sea Treaty. Timor Sea. Timor Sea is near East Timor, Timor-Leste, called Timor-Leste, and Australia also. They are sharing the continental shelf, so that is why they have a treaty. But there are disputes over this delimitation of the continental shelf under the Timor Sea Treaty. It is submitted to arbitration through PCA in 2015. The first one is the year of submission of the case arbitration, and this 42 is case number. In this year, case number how many? 2015 submitted, case number 42. The second case, the Arctic Sunrise arbitration between Netherlands and Russia, 2014, case number 2. The South China Sea arbitration, Philippines versus PRC, China, 2013, case number 19. And this fourth one is including Malaysia, the case including Malaysia, railway land arbitration, Malaysia versus Singapore, 2012, case number 1. This is the dispute over interpretation of the 1990 Points of Agreement, POA, on Malayan railway land in Singapore. It's a very long-standing dispute between Malaysia and Singapore, and this was brought to arbitration through the Permanent Court of Arbitration. And the award appears to be in Malaysia's favor. If you want to see the cases, you can go and visit the PCA website. All the arbitration cases through PCA are there, and you can open and download the case. Is Chagos Marine Protected Area arbitration between Mauritius and UK. Very famous, the international law of the sea dispute. Another one, Bay of Bengal maritime boundary arbitration, Bangladesh versus India. There are two very important cases relating to Bay of Bengal. Bay of Bengal is between Bangladesh and India. This is one case between Bangladesh and India was submitted to this arbitration through the PCA. But another case is Bangladesh versus Myanmar. Another maritime boundary delimitation in the Bay of Bengal. It was submitted to the ITLO, International Tribunal for the Law of the two Bay of Bengal cases, which are very important maritime delimitation cases. And another one is also including Malaysia, land reclamation by Singapore in and around the Straits of Johor, Malaysia versus Singapore. You may remember that this is also a case submitted to the ITLOS, International Tribunal for the Law of the Sea. First submitted to the ITLOS, and then finally submit to the arbitration. For the final binding decision, they submit to arbitration. And then another one, maritime boundary delimitation arbitration between Guyana and Suriname. A few only. There are many maritime boundary cases, so many, which is facilitated by Permanent Court of Arbitration. So any questions on the leading cases on arbitration?
No, Prof.
Okay. Now, we will emphasize more. As a case study, we will discuss on the South China Sea arbitration, which is very important and famous arbitration, which is including Malaysia, all the very, very hot dispute between neighboring countries, including Malaysia, on South China Sea. But the arbitration itself was initiated by the Philippines against China. Other countries are not involved. The Philippines versus China, South China Sea arbitration. What is South China Sea? So which is a very, very, important area. Why is it important? Because there are 3-4 factors. This is a semi-enclosed sea. Semi-enclosed, not totally enclosed, semi-enclosed, half open, half enclosed. Around 3.5 million square kilometers, so big. The South China Sea is so big, 3.5 million square kilometers. And it's a crucial shipping lane. All the countries from the East Asia, China, Korea, Japan, all the countries, Vietnam, all they have to pass through the South China Sea to get to the West, to get to the Africa or Europe or America. So that's why this is very important area, crucial shipping lane. Number three, it's a rich fishing ground. It's rich with so many types of fish. And number four, it holds substantial oil and gas resources. Very important, right? Oil and gas resources. Substantial oil and gas resources are there. So no wonder these countries are disputing for so many years on these islands and the atolls in the South China Sea. And South China Sea touches the coast of 7 countries, and 5 of which are actively competing claims to the waters of South China Sea. The 5 are China, Taiwan, the Philippines, Vietnam, Malaysia, and Brunei. Singapore and Indonesia are not actively included in the competition in the South China Sea, but there are some other disputes, like for example, Indonesia, we have dispute over the islands. I will show you later on the maps, some islands, but which is outside the South China. That's why in South China's dispute, Indonesia was not involved. So also Singapore was not involved. So in the South China Sea, there are hundreds of maritime features. We use the term maritime features because it can comprise all types of features. Because there are so many terminology, right? Islands, islets. Island is very small, tiny islands. Atoll, atolls, and then shoals, low tide elevations, rocks, so many things. So that's to cover all, we use the term maritime features. Maritime features, either above or below sea water. Some are below sea waters, some are above sea waters. And some of these maritime features are subject of long-standing territorial dispute amongst the coastal states. Now, how this South China Sea arbitration started? The beginning was the action done by Malaysia and Vietnam in 2009. Malaysia and Vietnam jointly submitted their claims on the EEZ beyond 200 nautical miles. According to the international law of the sea, exclusive economic zone, right? Exclusive economic zone is normally up to 200 nautical miles. Okay, easy. But it can also be the continental shelf. Continental shelf can go beyond 200 nautical miles. Continental shelf can go beyond 200 miles. Natural gas, the oil and natural gas are extracted from the continental shelf. Even though beyond 200 nautical miles, so the seawaters are high seas, but the seabed and subsoil are still under the jurisdiction of the coastal states. If they want to claim continental shelf beyond the easy limit 200 nautical miles, then they have to submit to the Commission on the Limits of the Continental Shelf, which is established by the UNCLOS 1982 Convention on the Law of the Sea 1982. So that's why Malaysia continental shelf is Malaysia water is very shallow water, so that Malaysia can claim continental shelf, that is seabed and subsoil, beyond 200 nautical miles easy. So that's why, together with Vietnam, Malaysia teamed up with Vietnam and submitted this to the Commission on the Limits of the Continental Shelf. When Malaysia and Vietnam submitted like this, China sent a notes verbatim, official diplomatic notes verbatim, to the United Nations Secretary General. And they attached a map depicting the 9-dash line. So the 9-dash line was started using by China since 1948. But this is now the first time they officially use this 9-dash line, a map including the 9-dash line, and submitted this to the United Nations Secretary General. And they argued that China had indisputable sovereignty over the islands in the whole entire South China Sea and also the adjacent waters. First, sovereign over the islands, and also it has sovereign rights and jurisdiction over all the adjacent waters. It's the first time China officially claimed based on 9-dash line, which is very, very famous, and so many scholarly articles you can find on this 9-dash line, Chinese claim of 9-dash line. So these Chinese diplomatic notes were first initially rejected by Malaysia and Vietnam, because Malaysia and Vietnam doesn't like that, because Malaysia is now claiming Indonesia natural resources of Indonesia, which goes beyond 200 nautical miles EEZ. So that's why Malaysia doesn't like it. Malaysia rejected this. Vietnam also rejected this. And later on, Indonesia and the Philippines also rejected this China claim on the South China Sea within the 9-dash line. Okay, now this is the map. China's 9-dash line. Why it is called 9-dash line? Because you see red color line, right? This is red color. 1, 2, 3, 4, 5, 6, 7, 8, 9. So all the sea waters within these 9-dash line are, this is the South China Sea, right? So these areas are China claim that all the islands and all the atolls and other maritime features are owned by China, and also all the waters, territorial sea, EEZ, Indonesia, owned by China. We can see how greedy is China, you see. It's very far from China. Mainland China is a mainland China, right? It's very far from it. It's near Malaysia here, close to Malaysia, Sabah and Sarawak, close to Brunei. This is Natuna Island is claimed by, this island is claimed by Indonesia, but this is outside the 9-dash line. That's why Indonesia was not involved in the South China Sea dispute. Why? Because the Natuna Islands claimed by Indonesia is outside the 9-dash line. But the Malaysian claims of the EEZ beyond 200 nautical miles, Brunei claim, Philippines claim, and the Taiwan claims and Vietnam claim all are clashed with China claim of 9-dash line. Okay, so the claims of each and every country can be seen in the second map. The second map is a more detailed map. Okay, in this map, you can see the Malaysian claim. This green color ones are Malaysian. This is the East Malaysia. This is the Malaysia, but this is outside the 9-dash line claim. But here in Sabah and Sarawak, this green color one is Malaysian claim beyond and up to 200 nautical miles and beyond 200 nautical miles EEZ, all the natural resources Malaysia claim. So this is the Malaysian claim. This green color one Malaysia claim. This yellow color one is Brunei. Brunei claim is here, this area. And Philippine claim is this purple color one. All these areas clash with China. So many areas are clashed with China's 9-dash line. And Taiwan claim, this is, I mean, what color is this? Greenish blue, greenish blue color. This is Taiwan claim. And Vietnam claim is the blue color. All the blue colors are Vietnamese claim and very much clash with China's claim, right? And all the Expressway Islands, Paracel Island, all these are included in the Vietnam and claims and China's claim. Clash. Okay? So you look at the maps, you can see very clearly how many 5 neighboring countries are affected by China's 9-dash line claim. And since that time, 2009, China steadily increased efforts to consolidate its position in the South China Sea by using various means and methods and techniques. And then extracting the resources, the fish, to stand the Chinese fishing vessel and to fish in the South China Sea, and they extract the natural resources in the disputed areas. And starting from 2013, they construct artificial islands by land reclamation, sending lands and cements and stone from outside, and then enlarge the existing maritime features. The lower elevation, they put all the cements and sands and rocks, and they make become up to the sea level. It becomes an island, artificial islands. Okay, and then they make military bases there and civilian asset like intelligence, devices there, or everything is established on these islands. So many countries are opposing this, especially Philippines was the most vocal against Chinese activities in the South China Sea, and there are many clashes between the Chinese Navy and Filipino Navy in the disputed area. But Philippines cannot match with China's power, right? Economically, diplomatically, militarily, cannot match with China's big power status. So that's the effect. Philippines finally decided to submit to arbitration through the Permanent Court of Arbitration, PCA. So both states, Philippines and China. So this is in the under UNCLOS, United Nations Convention on the Law of the Sea, 1982. As I told you before, right? Part 15 deals with dispute settlement, and in the dispute settlement, arbitration is the major part. And also to implement this arbitration provision, Article Article 287, there are two additional, sorry, annexes, right? Annex number 7 and annex number 8. These two annexes are entirely on arbitration. Annex 7 is ordinary arbitration, annex 8 is special arbitration. So Philippines initiated this arbitration against China under part 15 of the convention in 2013, and then to decide dispute over the parties' respective maritime entitlements. Maritime entitlement means the claims on the maritime zone. We have, under the law of the sea, we have territorial sea, contiguous zone, exclusive economic zone EEZ 200 nautical miles, and then we have coordination of 4 maritime zones. We call 4 maritime entitlements. So these maritime zones or entitlements are based on the mainland or based on islands. Even a small island, they can have 12 nautical miles, territorial sea, 200 nautical miles EEZ, and more than 200 nautical miles beyond that, continental shelf of the seabed and subsoil and all the natural resources. So that's why even small islands are very important. So that's why the parties are disputing over the maritime entitlements and all Chinese activities in the South China Sea. These activities are clash with the Philippines maritime entitlements. So these are the 3 points asked by Philippines to decide. Number 1, to declare whether China's claims based on the 9-dash line are valid or invalid under UNCLOS, UN Convention on the Law of the Sea. 9-dash line is valid or not. Number 2, to declare whether certain land features in the South China Sea, there are many maritime features, right? Whether they are rocks, islands, or low tide elevation. So three types of maritime: rocks, islands, or low tide elevation. Low tide elevation has no maritime entitlements. Islands have all the maritime entitlements, but it is rock which cannot sustain human habitation. They have less maritime entitlement. So that's why the what they call a classification of the maritime feature are the rocks, are the islands, are the low tide elevations. The maritime entitlement will be different. So that's why the Philippines asked the arbitral tribunal to decide what are the position or nature of these maritime features. Are they rocks or islands or low tide elevations? Number 3, to declare whether China has interfered with the Philippines' right to exploit resources within the Philippines claimed water, Philippine EEZ and continental shelf, whether China has interfered in the exploitation of natural resources, oil and gas. These are the 3 questions asked by Philippines to the tribunal to decide. China entirely rejected this arbitration procedure, and they formally informed this to the Permanent Court of Arbitration. And China, because of this, China's non-participation in arbitration, there are two parties, right? In a dispute, there are two parties. One party initiated the arbitration, but the other parties rejected the arbitration, meaning that the other party doesn't want to participate in the arbitration. So that is why the arbitral tribunal, PCA and arbitral, has to rely on Article 9 of the Annex 7 of the UNCLOS Convention. Because the Article 9 relates to the situation of non-participating party. And the tribunal decided that based on Article 9, the tribunal decided that China's non-participation did not bar it from proceeding. Article 9 allows that even though one party is not participating, the tribunal can proceed, can go ahead. It is not a bar from proceeding with arbitration proceedings. But China also not only not participation, but also did not exercise its right under Annex 7 to appoint one of the 5 arbitrators. First, the two parties, each party have to appoint one arbitrator each. Philippines appoint their own arbitrator, one arbitrator, but China refused to appoint its own arbitrator. And also, the other remaining three arbitrators are to be jointly discussed and agreed between the two parties. But also, China did not join to appoint another 3 arbitrators. So finally, based on the Annex 7, Article 3, the president of the International Tribunal for the Law of the Sea, it lost. Because this Article 3 is Article 3 of the UNCLOS, right? UN Convention of the Law of the Sea, and the main body of the judicial body of arbitration body of the UNCLOS is ITLOS, International Tribunal for Law of the Sea. That is why President of the ITLOS made the appointments of the necessary arbitrators. Finally, the arbitral tribunal was formed. And who are the arbitrators here? You see the arbitrators. Arbitral tribunal facilitated by the Permanent Court of Arbitration, South China Sea arbitration. 5 tribunal consists of 5 arbitrators. The first one is Judge Thomas A. Mensah. He is the presiding arbitrator. He was the former president and judge of the ITLOS, International Tribunal for the Law of the Sea. The first founding president of the ITLOS. He is a very experienced judge. Second arbitrator is Judge Jean-Pierre Court. He is a sitting judge of the ITLOS. Third one, Judge Stanislaw Polak, current sitting judge of the ITLOS. Judge Rudiger Wolfram, that is chosen by Philippines, current sitting judge of the ITLOS. And there's one academic professor, Professor Alfred Soons, is a professor of the Institute of Public International Law, Utrecht University. So all these are arbitrators in the South China Sea arbitration, which was facilitated by the PCA, Permanent Court of Arbitration. Now, China, even though China did not participate, he sent documents to protect its own. They sent documents to protect their own rights, and China objected to the jurisdiction of the tribunal. China objected and argued that this arbitral tribunal has no jurisdiction. So objected to the jurisdiction of the tribunal on 3 grounds. Number 1, the subject matter of the arbitration is the territorial sovereignty over several maritime features in the South China Sea. It's the territorial sovereignty case. The main subject matter of the arbitration is to decide on the territorial sovereignty over maritime features. And that is why it is beyond the scope of the convention. It is not related to interpretation or application of the convention. It is related to decide on who owns the maritime features, territorial sovereignty over the maritime features. This is not within the scope of the convention, for one. Number 2, So China and Philippines have agreed through the Declaration on the Conduct of Parties in the South China Sea. This is called Declaration on Conduct of Parties. The China and other ASEAN countries together how to settle, how to resolve these South China Sea problem disputes. They make a declaration on the conduct of parties in the South China Sea, and they agree that they should settle their disputes through negotiations. Because of the influence of China, other ASEAN countries are smaller than China, right? So that's why they agree that okay, let us settle this through negotiation. China want to settle through negotiation. China is always a big party, right? A big country, so always it can influence other countries. That's why must be one by one negotiation. China and Vietnam, China and Malaysia, China and Brunei. So China and Brunei or China and Malaysia. Malaysia is a small body. China is a big body. How can Malaysia compete with China's claims? Right? Very difficult in negotiations. So now they argue that this is a declaration on the conduct of parties, and the declaration provides for settlement through negotiations, and Philippines breached this obligation under the declaration. Number 3, when accepting the joining the convention, China made a declaration, an interpretative declaration. In the Chinese declaration, China excluded disputes concerning maritime delimitation from compulsory jurisdiction settlement. Because this chapter 15 is compulsory jurisdiction, Article 287, compulsory jurisdiction. States have to choose either ICJ or ITLOS or arbitration under Annex 7 or Annex 8. You have to choose one. And this is whenever there's a dispute, they will be decided according to what is chosen by the parties. And China make a declaration that even though there is the arbitration tribunal under the UNCLOS, dispute concerning maritime delimitation must be excluded. If there is a dispute is relating to maritime delimitation, it must not be decided by the UNCLOS compulsory dispute settlement procedure. It's not compulsory for China. These are the 3 arguments made by China against jurisdiction of the tribunal. But tribunal rejected all these 3 arguments. The tribunal rejected all the Chinese grounds of objection. Because on the first point, the Philippines itself in a statement of claim expressly excluded dispute regarding territorial sovereignty. Expressly excluded. We are not disputing on territorial sovereignty of the maritime feature. Our case brought to the arbitration is excluding disputes regarding territorial sovereignty. No dispute over territorial sovereignty. That's why the tribunal decided that the first argument by China is irrelevant. Second one, and the tribunal found that on the second point, tribunal found that the declaration of conduct was not a legally binding instrument. This is just a declaration. You know very well, according to international law, we have the formal sources and material sources, or we have the law creating sources like treaty, convention, customary international law, and general principles of law. They are formal sources, law creating sources. And we have material sources or soft law principles like declaration. Declaration is soft law principle. It is not hard law. It's not legally binding. This is mere declaration only. Declaration, not a treaty. Declaration of conduct was not a legally binding treaty. So that is why not necessary to comply with this declaration. The third point, also in the statement of claim, Philippines expressly excluded dispute regarding maritime delimitation. The case is not entirely about maritime delimitation. It is nothing to do with maritime delimitation. And Philippines very clearly excluded dispute over maritime delimitation. That is why the tribunal concluded that all the 3 arguments, objection of China made against jurisdiction of the tribunal are rejected, and the tribunal finally decided that it had jurisdiction over the case. Any questions on the issue of jurisdiction? Any questions? Okay. Okay, now let us look at the ruling on the merits of the case. So this is final award, arbitral award on the merits of the case was adopted, issued by the Permanent Court of Arbitration on July 12, 2016. This is the official issuance of release of arbitral award. And the award was overwhelmingly favorable to the Philippines. That's why China was very angry. Right? The award was overwhelmingly favorable to the Philippines' position. And it decided that several elements of China's claims in the SCC are unlawful. Okay? And key findings of the ruling are: number one, China claims to historic rights and resources with its 9-line have no legal basis. So this one is you want to know detail about this one, historic rights. 9-line is based on historic rights because China, since 1948, we wrote, and many Chinese scholars also wrote articles, and Chinese government also made announcements that the Chinese Navy has been going around the South China Sea and patrolling around the South China Sea since 17th, 18th centuries. Because of that, China has the historic rights over South China Sea. So their action of the Chinese Navy, mainly based on the action of the Chinese Navy in the 16th, 17th, 18th centuries. But they do not talk about in the 19th or 20th century, 21st century, because there are so many changes and then many other claims made by other countries, like even France. France occupied all the South China Sea, all the Presley Island and Paracels Islands, and even we have Indochina, right? Why we call Indochina? So this is under the French colony. Vietnam, Cambodia, they are French colonies. And there was a war between the Franco-Chinese War, and China was defeated, and that's why China could not invade this Vietnam and Cambodia, and they were under the French, and all the islands are owned by France. And Second World War, all these islands in the South China Sea are owned by Japan. Japan occupied all these islands, including even Malaysia was occupied, right, by Japanese, right? So that is why the historical rights are, first, it must be continuous. The 18th century, 17th century, Chinese vessels, Chinese naval vessels go around and patrol around the South China Sea at that time. But in the 19th century, 20th century, 21st century, what are the changes of the situation? So many other countries are claiming competent claims in the South China Sea area. So that is why this is not good on solid ground for legal business for Chinese national. I write this very much in detail in my article on the land dominates the sea and the South China Sea dispute. You can read my article. Here I use a very basic principle of international law of the sea. The land dominates the sea. So that's why we have to look at the land. Who owns the land? China, mainland China is very far away from the South China Sea. Without the mainland, China cannot claim. And these Presley Island or these islands they're disputing. Malaysia is also claiming. Vietnam is claiming. Philippines is claiming. Right? China alone is not claiming. So that's why you cannot say that China can claim. No, from the land, without the land, mainland or island, nobody can claim on the sea. Because the original sovereignty rests on the land. From the land, we have to expand the maritime territories from the coast, right? Baseline, from the coast, baseline, 12 nautical miles outer sea, 200 nautical miles EEZ, and more than 200 nautical miles continental shelf. Because all the maritime entitlements of maritime zones are to be claimed from the land. That's why we got the basic principle of international law of the sea is that the land dominates the sea. Without the land, nobody can claim on the sea. And China is claiming sea areas which are very far away from the mainland China, and China could not prove very clearly that these islands in the South China Sea are owned by China alone. Okay? So that is why the tribunal decided that this historic claims, historic rights, or historic title has no legal basis, for one. Number two, none of China's claimed land features in the Pacific Islands are islands capable of generating a 2 nautical mile equivalent. They are not islands. But the maritime features claimed by China in the Spratly Islands or also Paracel Islands, they are not islands. They are some are rocks only, or some are even low tide elevation, and China later on changed the position by means of land reclamation and by upgrading to become an island by artificially. But according to the law of the sea, an island must be naturally formed area of land. Naturally formed area of land. It must be natural. Artificial islands has no right at all on international law. You cannot claim maritime zones, maritime entitlements from artificial islands. So that's why what China did was they upgrade the low elevation to become an island. They upgrade an atoll or coral reef to become an island. So that's why the arbitration tribunal says that according to international law of the sea, only natural. You have to look at the natural one, original one. You cannot accept the man-made, extensions or creations. This is not in accordance with international law. So that is why even a rock, they can claim only 12 nautical miles from the sea, only no EEZ. But low elevation, no claim at all, no maritime entitlement at all. This is the second point, according to that. The third point is regarding the rights of the sovereign rights on natural resources in the South China Sea. The tribunal decided that China violated the Philippine sovereign rights by interfering in the exploration activities, fishing activities. That is also China was responsible, and China violated international law of the sea convention. And also China also violated its obligation under the marine environmental protection. Because of this land reclamation and the upgrading the low tide elevation, it affects the marine environment. Pollution and also sea species were affected by this land reclamation. So that is why all the decisions of the arbitral tribunal are against China and in favor of Philippines. Okay, but as you all know, China is a big power. From the very beginning, they object to the arbitration tribunal. They do not accept the tribunal, and finally, when arbitral award was made, they declared that they will not accept and comply with the award of the tribunal. But anyway, the tribunal decisions are good for academically. It's good, and it can explain so many unsettled the international law principles, law of the sea principles on maritime features and on the historic title, right? All the controversial legal principles were explained by the tribunal, and it is, from academic point of view, it's a very good and well cited arbitration